Hi, good afternoon. So my name is Mohammed Faridi, and I am the president of the New York City Bar Association. And it is a privilege for us to welcome so many of you to our association tonight. We have a 155-year-old history for standing up for the rule of law and for ensuring that the legal profession serves justice, not politics. Tonight's gathering takes place against a backdrop of immense urgency. The events of recent months have brought us to a line that we cannot afford to cross, a line where lawyers are no longer seen as officers of the court, but as political adversaries, where advocacy itself is cast as disloyalty, and where legal ethics, constitutional norms, and the independence of the profession and the judiciary are threatened by raw political power. It is very fitting that this event is taking place just a few days before Law Day, May 1st. Law Day is a tradition that was established by President Dwight Eisenhower to recognize the centrality of the law in democratic life. And in his 1958 proclamation establishing Law Day, which is worth reading and rereading, President Eisenhower urged Americans to vigilantly guard the great heritage of liberty, justice, and equality under the law. Those are the words that are worth recalling now. Having grown up in the Indian subcontinent in Pakistan, I know firsthand the dangers that arise when lawyers are penalized for representing the persecuted, and when judges are threatened with retribution for the decisions that they make. In such an environment, the law becomes more a tool of those in power than a shield for the vulnerable. The result is not just the erosion of independence of the profession and the judiciary, but the unraveling of democratic institutions and norms. The rule of law is not self-executing. It requires institutions willing to enforce it, lawyers willing to defend it, and a culture that supports both the lawyers and the institutions. Recent events in our country have tested that culture in serious ways. The executive orders that target law firms, not based on any unlawful conduct, but on whom they employ, who they represent, and what legal positions that they have advanced, are contrary to the moral fabric of our country. And while judicial decisions are not immune from public scrutiny, there is no justification for public attacks on judges, refusals to enforce judicial orders, and for calls to impeach judges based solely on disagreements with their rulings. Unfortunately, the attacks on the profession are working. In some instances, law firms have reportedly declined to take on clients or matters that may draw political attention. And we have all heard about the terrible pressure that the executive branch has put on firms to align their work, their pro bono work, with the goals of the administration. The trend should alarm all of us. The harm here is not confined to lawyers. It extends to clients who depend on independent legal representation. It extends to the courts that rely on adversarial advocacy. It extends to the public, whose rights often hang in the balance of a legal system that must operate free from coercion. There is also a historical dimension that we cannot ignore. Attempts to convert lawyers into extensions of the executive branch have marked the decline of democratic systems elsewhere. America's tradition is supposed to be one of constitutional restraint and of respect among the co-equal branches of our government. The willingness of the executive branch to disregard or defy judicial rulings mirrors practices seen in parts of the world where executive enforcement of court decisions are inconsistent, are politically motivated, or are ignored entirely. The result is predictable. Judicial authority erodes and democracy suffers. Our Bar Association believes that it is important, indeed it is essential, for bar associations to speak up for the rule of law and for the judiciary, because bar associations occupy a unique and credible position within our legal and civic framework. That is why we have acted, and we will continue to act, to defend the role of lawyers in our democratic system, to resist efforts to compromise professional independence, and to stand up for our judiciary. We do not take these positions lightly. The legal profession thrives when it is open to scrutiny, rigor in debate, and commits to self-correcting. But there is a bright line between criticism and coercion. There's a bright line between political disagreement and political punishment. And there is a bright line between the rule of law and rule of fear. These lines must be defended clearly, publicly, and unequivocally. What we are witnessing today is not normal, and it must not be normalized. So let us be clear. Lawyers do not serve the executive, they serve the law. Judges are not instruments of political will, they are guardians of constitutional rights. And the independence of our profession is not a favor to be extended or withdrawn. It is a structural necessity for a functioning democracy. Thank you for being here tonight, and let me turn it over to my colleague, Chris Pioch, who will introduce our next panelists. Thank you.
Thank you, Mohammed. Good afternoon, everyone. My name is Chris Pioch. I am the chair of the City Bar's Task Force on the Independence of Lawyers and Judges. I'm here today. I'm joined by two phenomenal panelists. I have Judge Shira Scheindlin, who served as the Chief Administrative U.S. Attorney and Deputy Chief of the Economic Crimes Unit at the U.S. Attorney's Office for the Eastern District of New York. She was also General Counsel of the New York City Department of Investigations and a magistrate judge for the Eastern District. Judge Scheindlin served as a United States District Judge in the Southern District of New York for 22 years. And additionally, she sat by designation on the U.S. Court of Appeals for the Second and Ninth Circuits. Judge Scheindlin retired from the bench in May of 2016. Since then, she's overseen mediations, arbitrations, served as a court-appointed special master, mock trial judge, and an expert witness. Judge Scheindlin has received numerous awards for her contributions to the profession, and she's currently of counsel at Boies, Schiller, and Flexner. Thank you, Judge Scheindlin. I'm also joined today by Dean Emeritus Matthew Diller. Matthew Diller served as the Dean of Fordham Law School from 2015 to 2024. He was my dean. While there, Dean Diller launched the Access to Justice A2J initiative at Fordham Law School, which promotes teaching and scholarship in access to justice issues. In addition to access to justice, Dean Diller also lectured internationally on issues related to the U.S. constitutional system and is the recipient of numerous awards for his work and scholarship. Prior to being appointed Dean of Fordham Law School, Diller served as the Dean of Benjamin N. Cardozo's School of Law. He began his teaching career at Fordham, however, where he was named as the Cooper Family Professor of Law and co-directed the Lewis Stein Center for Law and Ethics. Earlier in his career, Dean Diller worked for the Legal Aid Society and was a law clerk to the Honorable Walter R. Mansfeld of the United States Court of Appeals for the Second Circuit. So welcome, Dean Diller. So our panel today is about safeguarding the judicial process, and we have the next 40 to 50 minutes or so to really have an open dialogue and an open conversation about what that process is, what that means for individuals. I was going to start, I think, by asking each of our panelists to help frame this narrative by really talking about what independence of the judiciary means to them personally. I think it's hard to follow up Mohammed's excellent opening statement. But I think in order to sort of bring it home and to help frame our conversation, it would be very helpful for us if we just asked each one of us, and I'll start with Judge Scheindlin, what does the independence of the judiciary mean to you as a former judge?
Well, thank you. Thank you all for being here, and thank you for the very fine remarks of the president of the association. I think he laid it all out as well as it can be laid out. But I do want to answer your question directly. What it means to be an independent judiciary is that you can do your job without fear, without having to worry that a decision you make could result in your being fired, which happens in many other countries. If you don't rule the way the executive wants, well, you're fired. And by the way, that's true here with immigration judges. They work at the pleasure of the executive. They can be fired. They're not Article III judges with life tenure. So you have to realize that those judges live in the kind of fear that the Article III judges do not. So I think it means, independence means you do what you think is right. You apply the rule of law, and you're only bound by what you believe the law says. Now, that said, different judges will have different interpretations of the same law. But in our country, that should be grounded in our Constitution. If there's real respect, you go to the Constitution, you read it carefully, and concepts like due process, which have been disappearing lately, are there. It's in the Constitution. Everybody's entitled to due process, not just citizens. Every person, that's the word, every person in the United States is entitled to due process. So when I was a judge, I took all of that very seriously. I knew that some of my decisions were not going to be popular with everybody. Some would like it, some would dislike it, very much so, and I'm sure we're going to get to that. But you do your job without fear. And I'm afraid the environment we're living in now is one of fear and intimidation. And maybe some lawyers have suffered from fear and intimidation, but I don't think any judges yet have suffered from fear or intimidation. If you look at what's been going on, the judges have been very brave, very courageous. Whoever appointed them, it didn't matter. Overwhelmingly, they've rejected many of the executive orders. They've restrained them temporarily. They'll probably restrain them permanently. So I think so far the judicial branch has acted with integrity and with courage, and I hope they continue to do so.
So Matt, I'm going to ask you the same question, but you're a law professor and a constitutional scholar. So can you frame it in terms of the independence of the judiciary for up-and-coming students and young lawyers?
I will do that, but I will do it, I'm going to first focus on, I'll do it in a way that focuses on your first question, which is what does it mean to me personally? Because
Sure.
that, resonated deeply with me. And before I do that, I just want to say, looking out at this room, I see so many leaders of our profession here in this city, in our country, and I know that all of you feel super strongly about this issue. And I am so proud of the response of the City Bar on all of these issues, and want to be of assistance at this crucial moment, as I know we all do. But let me answer your question. Personally, I have been a law teacher for more than 30 years, and I have introduced new students to what it means to be a lawyer and what it means to practice law, and to the craft and art of forming reasoned arguments around legal principles and issues of equity. And the premise of all of that is that we are a profession that is based on this idea of discourse and reasoned discussion through which a reasoned decision emerges. And central to that idea, of course, is the idea is that there is a judge, there is a decision maker who will decide based on the law as persuaded by the arguments of counsel and the evidence presented. And that's at the heart of the system, and if you lose that, you've lost the whole system. So when I see what's going on today, I see everything that I, as a teacher, have worked for the past 30 years as at stake. I'll add one more, and I think that answers your question too, but I'll add one more dimension. Reaching back, you mentioned my days as a legal aid lawyer. When I was a legal aid lawyer, we represented clients who had no political power. They were really people who had no money, who had many barriers to participating fully in our society, who were often desperately trying to make ends meet and focused on protecting their family and getting through crises. And they turned to the courts. We turned to the courts as the one place we knew and we hoped that rights would be respected and the idea of equality under law would be honored, and we didn't always get what we wanted, but that availability of being able to plead our case to a judge who would rule based on the law and the precedent and the reasoned arguments was critical to the fairness in our democracy.
Well, I heard you speak about equity, fairness, legal principle, legal reasoning. And Judge Scheindlin, I've heard you speak about, climate of fear and intimidation. But let me ask you, and I'll go a little out of order. Right now, there's not a lot of faith in the judicial process. There's not a lot of faith in the judiciary. I think recent polls showed that only 35% of Americans actually believe in the work of the judiciary. So I'm going to start with Matt Diller at this time, because after everything you just said, which I wholeheartedly believe in, but it's very difficult to sort of rectify that against the numbers. So why do you think there is this sort of discrepancy in what we talk about right here versus what people are thinking about the judiciary?
So a couple of points on this. So one is, of course, we've had a loss of trust in all of our public institutions. And this, I think, is, loss of trust in the judiciary is a piece of that. And is a reflection of the growing polarization in our society. And so everything we're seeing playing out today is also a reflection of that polarization, and the courts are not immune from that in any way. And then the other thing that I think is important to do is to keep, as I try and do, is to keep both the ideals and the beliefs that I said a moment ago in my mind, and obviously I feel it very deeply. At the same time, one can be critical of institutions. So, the point isn't that one shouldn't be critical of institutions. We should be critical of institutions, and we should work to improve them and perfect them. But it's one thing to do that, and it's another thing to undermine them completely and delegitimize them. And so, I'm all on board, and I think we are stronger as a society when we critique our institutions, and the courts are not above that critique either. But we are playing with fire when we undermine the institution as a whole.
So asking Judge...
I don't know if I answered your question, but there it is.
I'll take it. I think you did. I see where you're coming from. I see the importance of bolstering the institution and wanting to believe and wanting to have faith in the institution. Judge Scheindlin, I'm going to ask you about something similar. Recently we're hearing more and more from judges who are talking about a loss of respect in the court system. You have calls to dox judges, private information. You're having articles being written in major media papers about the so-called judge's dilemma. What happens if a judge rules against the government and then government doesn't follow their order versus, if they don't rule at all and then lose public trust? So what are your thoughts about these kind of dilemmas and things that we're struggling with right now?
Well, Counselor, you did ask about 5 questions at once, so I'll try to group them by starting with answering the question that you just asked.
Fair.
Matt, which was?
The initial question is the loss of faith and trust in the judiciary.
Exactly, thank you. So what I think is the numbers are going to go up. It is true there was a loss of faith in the judiciary because what people read most is decisions from the highest court. And the highest court looked very politicized. When you get a lot of 5-4 decisions in June, and you don't like a lot of those 5-4 decisions, you feel that those justices came to their position out of their own political convictions. And so trust in the courts went down. But now you're seeing the lower court judges treating the issues that are happening before our very eyes. And as I said earlier, overwhelmingly, they are resisting these orders. They're finding them unconstitutional. They're writing wonderful opinions. And the circuit courts have done the same. I was so impressed with Judge Wilkinson's decision last week. I don't know how many of you read it. It's only 7 pages. If you haven't read it, read it. It is going to be an iconic opinion. It's going to be memorized. It's beautiful. And he, of course, was appointed by Ronald Reagan. So I think our numbers are going to go up. I think the 35% is yesterday, and I think this is the branch of the 3 that will get the most respect from the public. Now, that, of course, depends what happens at the end of the day in the Supreme Court. If 5-4 or 6-3, the president's orders are upheld repeatedly, then I think 35 will become 25. But if the justices apply the Constitution as it is written and stop these illegal orders, then I think the respect will rise. So I did want to answer that. Now, remind me of the other 5 questions. No, just give me a hint.
Talking about the calls to docs, I think
right,
this is more of a practice
Yeah,
question
sure.
directed at lawyers, right? I think I've heard from judges speaking recently concerning about whether or not
Yeah.
lawyers who are actually appearing before them are treating the courtroom with the same decorum and the same respect that they used to. And I guess the question is, do we have to be worried about that?
Well, that's yet another question. The lawyers who have been representing the United States in the courts have not been respectful. They have not answered the court's questions. I think they have lied at times, absolutely lied. I think they've supplied misinformation repeatedly, and that's unacceptable. For our United States Department of Justice to send lawyers to court to not answer judges' questions or to lie is a disgrace. And I think judges are calling that out. We have 2 judges now who are considering contempt, and they're right to do so. But I think most of the lawyers in most of the cases that appear throughout the country are very respectful. I'm not worried about most of the lawyers in this room or anywhere that I know who are being disrespectful. I'm worried about the lawyers for the United States. So that said, now there's the problem of enforcement, and I know everybody wants me to address that, or me and everybody else to address it. What can the courts actually do at the end of the day if their decisions, their orders aren't carried out? Well, they don't have much they can do. Criminal contempt is one thing, but that's not going to work very well against the United States because the president will pardon anybody who's convicted of criminal contempt, or maybe even who's charged with criminal contempt. So that's the only really big tool in the toolbox. What they need is support from the legislative branch, which has been painfully silent. I don't know how many of you are as sad as I am about the legislative branch failing in its duty to insist on its constitutional role, which this executive seems to take over. And until they stand up, until the Senate stands up and the House stands up, we're going to have a real problem. So here, if the court issues an order and contempt is not the answer, there's nothing much a court can do. As you know, it doesn't have an army. It can't tell the United States Marshals to march somebody to a prison because the U.S. Marshals are in the executive branch. So it is a judicial dilemma. All it can do is write the kind of wonderful opinions that Judge Wilkinson did, that Judge Boasberg did, that Judge Zenas did, and I believe there are many judges who will continue to do that.
I'm going to jump in a little bit,
good.
and I agree with that completely, and I would add a couple of things. I think a lot of what we're seeing is an attempt to undermine the lower courts in particular, to attack the judges on every possible level, both ad hominem attacks, attacks to the power of the district courts in terms of ability to issue injunctions and relief, and attacks on the lawyers who appear in the courts and who bring the cases. It's a full frontal assault on the lower federal courts in particular. I think we're not there yet on the Supreme Court. It may happen, but the focus has really been on the lower courts. And as Judge Scheindlin said, the lower courts have really, those judges have really stepped up. And I think that part of what's going on is setting up a scenario where if the administration crosses the Rubicon and says, we're just blowing off this judicial decision, they will have laid the groundwork by having done a systematic, methodical campaign attacking the integrity and role of those lower courts. And it's really going to be up to the Supreme Court to shut it down.
And I need to jump back in. I forgot to answer one of your 5 questions, which was, what about these sort of threats to judges? You mentioned doxing, and I don't know how many have read about the pizzas, the pizzas, outrageous. They've been sending pizzas to the homes of judges, and some of them have been sent in the name of Judge Salas's son. How despicable is that? So the pizza allegedly comes from this poor fellow who was killed, the judge's son who was killed. And they're sending these to many, many judges with notes such as, "You're next." I mean, this is really personal and frightening when you think that judges have lost husbands, parents, and children, and some judges themselves, of course, have been assassinated. So to think that hundreds of pizzas, and by the way, this time they're paid for, which apparently is a big difference in terms of delivering them. They don't ask for the money. So they're actually spending money. Somebody's spending money to do this. So getting the personal information of judges, doxing them, a new word in our vocabulary, sending pizzas out. I am so outraged. I don't know what to say. And even this impeachment stuff, nobody's going to be impeached. I'm confident of it. There's not enough votes to even pass the article, much less convict them, so I'm not worried about it. But what does it do to you as a judge? What does it do to your family? How do you feel about that? Right now, as I said, I don't think a judge is being intimidated by that, but it's despicable. There's no basis for it. In our whole country's history, I think there have been 13 impeachments, and those were for real crimes, like taking bribes. And one of those who took bribes became a congressman after he wasn't a judge, so there you have it. But these people, these judges, where they're bringing articles of impeachment, have done nothing but rule as they think is right. So I did want to answer that, too.
Thank you. And I was going to sort of touch on this idea of threats, right? Threats to the physical safety of judges has increased by something like 2,000% over the last 5 years. The numbers are absolutely astounding and incredible. And I guess the question here is, what do we do when we're dealing with this? How does, as you alluded to, it's obviously a judge does not like the idea of being threatened. It's not good. I'm sure you can opine a little bit more about that, given your own experiences, and maybe that would be very helpful for folks. But I think we need to remember that these judges are just people too. They're doing a job. And so the question really is, so what do we start to do to combat that just as regular people?
Well, we do what we're doing today and what we thank the New York City Bar Association for doing. Judges can't really speak out much and defend themselves, although I think they can do some things. Some of the judges write. We've had op-eds by judges, sitting judges. We've had articles in very important publications by sitting judges. And of course, judges speak through their opinions. So I think even sitting judges can speak out to some degree. But we depend on the lawyers, the bar associations, to speak for us and to defend us. So we urge you, I say we, I shouldn't, but we formerly, we depend on you to defend a judge when a judge makes an opinion, issues an opinion that may not be so popular, but may be what they really believe is right, and they're attacked. We depend on you to make a statement, and this bar association does, and I think bar associations throughout the country are doing that. The other thing I would say is we are stronger when we act collectively. And that was really the shame, I thought, in what happened with executive orders to law firms. If the law firms had all acted collectively, had all stood up together and resisted those clearly unconstitutional orders, thank you. If they had done that, I think those orders would have quickly disappeared, to tell you the truth. But we didn't. There was a split. Some fought, some negotiated. And by the way, I understand some of the reasons that those who negotiated chose to do so. I'm not here to criticize them. There were certain reasons they did what they did. But if they had stood together, so that's a very important point to make, that we only can succeed collectively. And I wish we had resisted collectively.
So the one thing I would add, in terms of sticking up for judges, it's, of course, critically important that this association does it as it has been doing. It's critically important that associations in around the country do it. It's the people who have the most influence at this point would be, the people in Ohio, in Michigan, in Wisconsin, in all of those swing states, in the red states, because it's when they speak out in defense of the judges that they're likely to get more attention from their representatives. I agree with Judge Scheindlin that the one way or another, the only way we get through this is if Congress wakes up at some point. And so the strategy should be, how do we bring that about? And, how do we mobilize the forces in support of the rule of law in Congress? And hearing from people in their own districts is the way to do it.
Well, you both sort of mentioned, and I'm going to throw in another question. I hope you don't mind. You both sort of mentioned politics in various ways, right? We have both, people in the red states who need to get more active to defend the rule of law. We have sort of these legislative actions that are occurring, the articles of impeachment you referenced. We've also had sort of this longer-term tradition of calling judges by, the president that appointed them, a Reagan judge, a Clinton judge, an Obama judge. Does that impact the independence of the judiciary? Does that impact the perception of the judiciary as sort of this not quite so apolitical branch of government?
Well, first of all, I think that's a very good question, because judges are often referred to as an Obama judge, a Trump judge, a Biden judge. I understand that. And the presidents do have a right to pick at least the justices, if not some of the lower court judges, who agree with them politically. That's the way it is. They were given the power to pick, and the Senate is given the power to confirm. And by the way, sometimes the Senate has not confirmed a presidential pick, as you know. Some people have been turned down. But in recent times, by 50 to 49 or 51 to 49, we've seen these confirmations, and that has politicized the image of the Supreme Court, for sure, that every nomination now is 50-50. It's party lines. It's a straight party line vote. By the way, as is our cabinet. But anyway, party line votes is what we're seeing. So the judicial branch, in that sense, looks very politicized. But I think this recent time is actually going to help, because I know it's the third time I'm saying it. I apologize for that. But we've seen judges who are appointed by all different presidents and all different senators sticking to the rule of law. They've really stood up. It's the one branch that is the guardrails, is the resistance. Can you imagine if we didn't have the courts right now? Every one of these executive orders would be carried out. So I think the judicial branch has shown its independence despite that impression of being politicized, which in a way can't be helped. So I'm not so terribly outraged that the media will always say which president appointed which judge. I get it. It's kind of unavoidable. But when they act sort of counterintuitively to what you might expect them to do, that's so good. That's why I think our popularity rating is going to go way up.
So another question for both of you. I think when we're looking at sort of these legislative measures, it's not just impeachments. And some folks might be familiar with this No Rogue Rulings Act that just passed the House. It deals with nationwide injunctions. So I'd like to get your thought about sort of judicial power, the power of the judiciary. Is it being curtailed by the legislative branch? Should it be expanded? What are we worried about? I'll ask both of you the same three questions.
So as I'm sure many of you have seen, the House passed this bill last week, 2 weeks ago, that would place tremendous restrictions on the ability of federal district courts to issue nationwide injunctions. And, there are a lot of serious issues actually underneath this. If you look at the rise of nationwide injunctions, it's really taken off over the past 20 years. And so there are, I think, issues one can debate and discuss about it. But I think it's pretty clear that the purpose of this bill now in this context at this moment is to take district courts out of the equation in terms of being an effective check on the executive branch. And so I don't think there's any two ways to see what this bill is directed at. The other thing I just want to draw your attention to is that the birthright citizenship cases, which the Supreme Court just accepted and put down for argument for May 15th, the principal argument in those that the Solicitor General is making is not about the underlying merits of the case. It's about the scope of the district court's injunctions in those cases. And so the government's position is that the district courts should be, granting birthright citizenship to the individual plaintiffs who brought the case, but should not be enjoining the policy nationwide. And if you just think for a few minutes about the implications of that, they're really staggering. And that's the issue that the Supreme Court has taken for May. And so we'll hear a lot more about this. But I think it's a key issue for whether the district courts will have the tools necessary to deal with what's going on now.
So I have a slightly different take on this. To me, it's all about whose ox is being gored. We didn't like nationwide injunctions when Judge Kaczmarek in a single-judge district in Texas was able to stop abortion pills, for example, being used throughout the country. We, I speak with a guess, didn't like that very much. So I have a problem myself with some nationwide injunctions. So there are things that need to be fixed, and I have several ideas. We should have no single-judge districts. It leads to the worst forum shopping, which, by the way, is what happened with the case being transferred from Judge Boasberg to Texas, because Texas and the Fifth Circuit are much more amenable to what the president would like to do than where the case sat in the D.C. Circuit. So that was, to me, blatant judge shopping. But so was going to these single-judge districts. So that they should be eliminated, and I think Congress is working on that to get rid of single-judge districts. Even two-judge districts gave us the very fine Judge Ilann Cannon. So that was also a lot of judge shopping there. So the other solution would be to have a three-judge panel. Not a bad idea. We do that for constitutional questions in the district court. We have two district judges and a circuit judge sit as a three-judge panel and decide constitutional issues. I have no problem with that if you're going to issue a nationwide injunction. I'm not sure it should be one judge. Sure, we like it now, but we didn't like it then. So I think a three-judge panel is an idea that's being kicked around, not so terrible. And then they would rule, and then it could go straight up from there, which is not a bad thing. So I can favor nationwide injunctions. It's just who should have the power to issue them. And we have to be kind of careful about nationwide injunctions, because usually we think of a judge only having jurisdiction over the parties in front of them. But it would be completely chaotic, as you said, if one district judge said, yes, there's birthright citizenship, this baby's okay, but the judge next door says not okay, not a citizen. That would be terrible. So there has to be an answer to this, but I think there is a solution.
Well, one thing that you mentioned, one judge district, two judge district, to my mind, that costs. So why don't we talk for a little bit about appropriations? Because I think, that is something that we have to address too. All of this costs some money.
Well, now that is scary. I don't know if you've heard what Congress had good ideas like, let's just defund the District of Columbia District Court. Let's just not give them any money. So wipe them out. That was one of their thoughts. We just won't give any money to that court. Or we won't give any money to any of the circuit courts. Who needs them? So they do have ideas on funding. They're not exactly popular, I think, in this room.
No, I think this is an Achilles heel of the system, right? Which is, in the end of the day, the judiciary gets its appropriations from Congress, and there's no real way around that. And then there are other issues like the cost of security, right? With all of this vast increase in threats against judges, there's a lot greater need for security, and that budget has not been increased in several years. And I think the Federal Judicial Council Conference just released a statement saying that in its view, the current funding is inadequate to deal with the situation now. But that, that lever of funding is a congressional power. And
by the way, this executive has used the removal of security protection as yet another tool. So there have been former cabinet members of his own, his former Attorney General, his former Defense Secretary, whoever. He says, you don't get any protection anymore, basically, because you weren't loyal to me during the election, you criticized me, so I'm withdrawing security. And that's in the face of actual death threats. So if you use that as yet another weapon, just think about where we are in this country.
Wow.
If you can, if you're willing to.
Yeah, I think, so let's talk, I guess, a little bit about our role, going back to, again, our role in safeguarding the judiciary and the judicial independence, right? We've heard a lot about what Congress does. We've heard a lot about, what the executive is doing. And all of this just sounds bad. So what should lawyers be doing? What should all members of the legal profession be doing to safeguard the judicial processes and safeguard the judiciary as a whole.
Other than what we've already said. Yeah, well, one thing is, do we continue to represent, as you alluded to this, people who need lawyers at the risk of infuriating the executive? Because the purpose of his going after these law firms is to stop all lawsuits against the United States, frankly, to challenge any of his policies, to challenge the people who are doing these things, to go after the agencies and being fair about benefits. So he's trying to dissuade lawyers from taking on issues that affect his policies. And so I think one of the things we have to do is stand up and not abandon those clients who need us to continue bringing the kind of lawsuits that we brought for a long time. Civil rights those words have a meaning, and we don't want to abandon our commitment to civil rights.
I think that's particularly important at this moment for the reasons that you said, Judge. And it's very easy to pass on the pro bono case because it could be controversial, because it could create heat, it could attract attention and appear in the newspapers. It could get attacked directly by the president. Now is not the time to pass on those pro bono cases. Now is the time to take those pro bono cases.
But I think firms are going to be worried about that. I know when you introduced me, you mentioned my firm name. I don't let anybody do that anymore. I mean, I have to be fair to the firm, and I think all lawyers are worried about that. If they take on a case, they could be drawing attention to their firm, which will be the next one to get an executive order. That's when you rule by fear, when you rule by intimidation. If lawyers are afraid to do that, and I can understand, again, why they have that fear, but they've got to overcome it. We can't abandon the role we've always had.
And just, to play it out a little further, you can look at it and say pro bono work, but that's a piece of the puzzle in providing representation. There are nonprofit groups and public interest groups. I don't think we're only at the very beginning of the attack on those groups, I think the 501c3 status of a lot of public interest groups is going to be under examination. Funding for the Legal Services Corporation, which can't bring a lot of these cases, but those lawyers are, of course, key. There are dimensions to our profession that have not yet been reached that I think will be reached imminently.
That's like him threatening to pull the tax-exempt status of Harvard. Right. It's the same thing. He could try to pull the tax-exempt status of a lot of foundations and organizations. I mean, we are seeing a weaponized time, is all I can call it, and we have to resist. The word is resist.
When we're talking about weaponization, I think one thing that you mentioned before, Judge Scheindlin, was the immigration judges, and I think one of the recent executive orders called into question, issues of attorney-client confidentiality with respect to, the immigration bar and also pro bono cases. So I guess the flip side of lawyers rising up and using the system and actively working on behalf of those pro bono clients would be the judges needing to make fair rulings with respect to issues of confidentiality and attorney-client privilege, standing up for sort of these traditional norms and in some case these statutory norms now. But I guess, do you foresee there going to be additional conflict as a result of judges continuing to do their job and as things get a little bit more pressure?
Well, I mean, the founders were very smart to come up with life tenure. It really does protect judges, but you do have to remember that many judges throughout our country in the state system are elected, and they face re-election, and they face recall, and they face the kind of funding you saw in this recent election in, was it Minnesota? Wisconsin, thank you, Wisconsin, indeed. The kind of money that was spent there, and the open bribery of the $1 million check from the guy who's now leaving the government, I read today, which is good news. But to think of that in a state election. So remember, there are an awful lot of judges who don't have the protection of life tenure. I told you earlier, the immigration judges don't. They can be fired. Elected judges don't. Judges subject to recall don't. We're very privileged in the federal judiciary to have life tenure. It really is a wonderful protection that our founders cleverly came up with.
I do think these issues ripple through the state courts
Yes.
in very, real and direct ways as, political leaders around the country try and ride the coattails of what the administration is doing. They do the same things in different versions at the state level. I do think in the end of the day, a lot will come back to the Supreme Court, and I don't just mean in terms of the big constitutional questions. I mean in terms of the messages that the Supreme Court sends out in terms of how it treats the district courts. Does it give the district courts the remedial power they're going to need? Does the Supreme Court keep jumping in every time the administration asks it to, and lifting stays, granting stays? The administration's goal here is to be in direct dialogue with the Supreme Court and to skip all those lower courts.
Yeah.
That's their strategy, and to date, the Supreme Court has really accepted that. Has really by granting all the emergency orders, by dealing with them, they are playing into the hands of the administration's attempt to cut out the lower courts.
And I think they'll continue to do it. In this recent order where the Supreme Court said that temporarily there'll be no more flights, indeed there were two dissents from Justices Thomas and Alito right off the bat. So there's 2 votes gone. I mean, you can forget it. They're not coming over. But interestingly, the 3 justices that Trump appointed in his first term did not dissent. It's so interesting to me that only those 2 did.
And that, by the way, that of course raised in my mind, as I'm sure it did in many of ours, which is the administration's blatant disrespect for the courts could come back to haunt them in front of the Supreme Court. That those justices could begin to think 2 or 3 times about giving the benefit of the doubt to this administration.
Well, I would also suggest that you all pray for the good health of the remaining 7 justices, because having watched the 3 of them not dissent, you can only imagine the people he would appoint now if he gets a vacancy. So let us pray. Let us pray for the health of all 7 who, I'm serious. He will not pick anybody like those 3 again. I know I can tell you who I think he's going to pick. They're in the cabinet.
Well, I'm glad you both brought up the Supreme Court, because I have a question about that. Right now when we're talking about sort of the loss of faith in the justice system and the judiciary as a whole, I think you're seeing right now the issues within the Supreme Court itself. We're seeing issues of, are people reporting everything that they're supposed to report? Are they taking bribes? As I think a big question that people have.
Well,
are we worried about that?
Your first question, we know the answer. No, they're not reporting what they're supposed to report. We had wonderful reporting from the media which exposed this. And, remarkably, it was the same 2 justices who just dissented. So Justice Thomas and Justice Alito seem to be taking benefits, shall we call it, from those whose political views they want them to espouse, and they do. Some of these people actually appeared before the court, or their companies did. So we need ethics reform, and you're more in touch with ethics and professional responsibility than I am, so go for it. Go for it.
No, I mean, part of the erosion of trust in the judiciary, which preceded this election, was around issues like ethics reform for good reason.
So I guess when we're talking about ethics reform, I'm just going to throw out there, how do you envision ethics reform should take? Is this something that, what I mean by that, broadly speaking, structurally, is this something that has to come down from the Supreme Court itself and saying we're going to bind ourselves? Is this something that the legislature has to involve itself in?
I think the legislature, there's no reason that the justices don't have to fill out the same financial disclosure forms that all the rest of the federal judiciary fill out. I filled those things out. It was a pain, but I did it, and all the other judges did it, and the justices, all 9 of them should do it too. So that would have made an enormous difference if they had to report on a form every year, not voluntarily if they feel like it, but a requirement. That's one thing. I also think the recusal issue has not been addressed appropriately. It's in their hands, and some of these folks seem to have no sense, no ethical sense, no moral compass. So I wonder if recusal there should be a way that has to be handled differently, maybe by the entire court. I don't know. I'm sort of making it up as I go along. And then people talk about, should there be some kind of term limit? Now, they would remain judges because they're judges for life, but should they be on the Supreme Court forever, or could they sit on lower courts and there would be a way of ensuring that every president had a number of appointments? So all of these thoughts have been tossed around, but whether there are ever the votes to do it, I doubt it.
Right, and of course, many of these were included in the Biden commissions.
Yes, yes.
The Commission on Judicial Reform that President Biden appointed, which was yesterday's attack on judicial independence,
Right.
as it was characterized.
And you know, now there's a bill kicking around for him to have, was it 200 new appointments? That he would pick new judges in this term.
So I guess a question that I have is, can we trust the legislature right now in this current environment? It really is. It's a question.
No.
And are we going to have to change that? How do we have to change that culture? I think where we're going.
That's easy. That's called the next election, which is less than 20 months away, whatever it is. That's what we have to do.
Right, I being the optimist, you know, so 'cause 20 months away seems really far when you look at the pace of events as they unfold. You know, my scenario, optimistic scenario, is that the Republicans in Congress in swing districts get cold feet.
Maybe.
Because if that happens, you know, their majority in the House of Representatives is so incredibly thin that the dynamic could change.
Yeah, I think we saw that with the tariffs. I think when the Republican senators began to speak out and were very critical and have to run in their districts, he changed his mind overnight. So it's true that if they would get some spine, I think that's what it's called. There's another word, but the spine sounds good. If they get some spine,
Yeah.
I think would make a difference. And I think you're right that both congressmen and senators might do that.
Or I don't know if they need spine, rather they need more fear from their electorate
That's the
than
same
from the
thing.
administration.
Okay, yeah, fair enough.
Well, I've been watching the time. We have about 4 minutes left. So if we each have 2 minutes, I'll give each of you 2 minutes maybe to give the audience some hopeful takeaways, things that we want to look forward to. Things that we want to look forward to.
I think the big hopeful, you know, the big positive takeaway, which we have both said, is that the lower court judges have just been magnificent, you know, and not across the country. So, you know, it's not just judges in New York and California and Massachusetts, it's really judges across the country who have, you know, at great personal risk, you know, taken strong positions to strike down blatantly illegal policies. And, you know, that heartens me. And they've been backed up by the courts of appeals time and time again. So I think that is the biggest single positive takeaway that we've seen, as well as we've talked about the, you know, issues in our profession in terms of will people take the unpopular cases. At the moment, the cases are being brought. And so there are lawyers who have done an incredible job in teeing up these issues for the courts, litigating in many jurisdictions, in many courts, all at once, day and night. You know, the ACLU's immigration team, it's unbelievable how many courts they can appear in at once and how fast they can turn things around. So we have seen incredibly, to me, heroic things, and we should count our blessings in that sense.
I couldn't agree with more, with everything that Dean said. I can't agree more. So do I have any other wise words to add to your already wise words? And I'm not sure, other than going back over some of the grounds that we've already gone over, which is that the judiciary, the judicial branch, is the independent branch, is the guardrails, and we're so lucky to have that branch constructed the way it is constructed in our history. Without that, people kept saying the second term, there's no guardrails, and there aren't. The president learned from his first term who not to appoint. So he's only appointed loyalists, cabinet members who have no qualifications at all other than their loyalty to him personally. So we have a rule, what they say, not a rule of law, but a rule of a man. And that's so dangerous, this going down the road of autocracy where you attack the lawyers, you attack the media. This is the way it happens. And we have to keep our antenna up and realize what's going on here is not normal. It's not normal. It's not acceptable. So all of us I think, have to continue to speak out in whatever way you can, whether it's through your cases, whether it's writing, whether it's speaking in your communities, wherever you can be heard, you should be heard. Do you know that this president has said that the DOJ lawyers can't go to ABA anymore? They can't go to the American Bar Association. Stunning. I mean, this one individual, his idea is censorship, cut down speech. Don't let anybody say what you don't like to hear. And we stand for exactly the opposite. We want to say, we want to believe in First Amendment. We want to believe in free speech. And if we don't exercise it, that's on us. So I want to say I think the judiciary has stood up, and I encourage you all to take that example and do the same.
All right, well, thank you. We are right at time, so I don't even think we don't have time to take any questions, actually. So we're right at time.
Any? Two? No?
We
Oh,
might
yeah,
be able to fit two
Let us
questions.
go over a little.
Let's see, one over there.
Okay.
First of all, I want to thank you all and the bar for doing this. The Bar Association has called for all lawyers to appear on May 1, Law Day, at, 1 o'clock at Foley Square. I am concerned. This turnout today is fantastic, but in all fairness, with all candor, it's basically the semi-retired, the soon-to-be-retired, and the retired.
Well, 4 o'clock. 4 o'clock.
Chris, you're doing a fantastic job. I just hope that the bar is going to and all of us in this room will reach out to our contacts, whether at firms, whether in government, whether at NGOs, nonprofits, whether at the law schools. Dean, I asked my alma mater's dean to spread the word to the 9 area law schools that every law student, professor, there should be at least 10,000, if not tens of thousands of lawyers marching for the rule of law on May 1st, Foley Square, 1 o'clock.
Well, that was excellent. I don't think there was a question in that, so I will take two questions.
Two questions.
Over here, in the front, yeah.
One more.
We have another
One.
question?
There you go.
Let's see, over here in the back.
That's a good question, and I do think that there are states that are taking action. I know that in California, they're doing certain, they've taken certain positions by legislation that at least will govern their state until it's challenged, and then we'll see what happens. But I do think you're right. I think state legislatures can make a difference. State Supreme Courts certainly are involved in redistricting. That's what Wisconsin was all about, and other states. So, yeah, I think you're absolutely right. The states are very important in what might be the resistance to this. Yeah, yeah, good, yeah.
All right,
Did you want? Oh.
Yeah, the only thing I would say is I think there is already an interesting dynamic going on with the states, which is when I think back to the second Bush administration, the states enacted all sorts of legislation designed to protect the environment, consumers, and fill some of the gap from the area that the federal government had retreated from, civil rights. I think this federal government will come after the states as well, so that will be another ground of contest.
They'll be back in the courts.
we do need to move this program along, so thank you both. And with that,
Yep, I'll be here. Or I'll move down one. Well, I'll move down one. I'll let the panelists. Yeah. Yeah.
Want to put someone here? One person here.
Go over there. All right. Talk about a tough act to follow. So we're the second panel today. Want to thank everyone for coming out tonight. It's a great event and great turnout. My name is Chris Wilds. I'm the co-chair of the Counsel on the Profession here at the New York City Bar. I'm joined by a distinguished panel. All the way at the end, Ben Berwick leads Protect Democracy's free expression and civil society defense teams. In that capacity, he oversees the organization's work to ensure that pro-democracy civil society actors remain resilient in the face of autocratic tactics and to protect the right to free expression and dissent that are required for a healthy democracy, which means he's busy these days. He has also led several of Protect Democracy's most significant litigation projects, as well as major efforts to ensure that the president is not above accountability and that the Department of Justice is not politicized. Ben is also a lecturer at Harvard Law School, where he co-teaches the Democracy and the Rule of Law Clinic. And before joining Protect Democracy, he worked for 6.5 years in the civil division of the DOJ. Next, Vince Warren. Vince is executive director at the Center for Constitutional Rights, where he is a leading expert on racial injustice and discriminatory policing. At CCR, he oversees the organization's litigation and advocacy work using international and domestic law to challenge human rights abuses, including racial, gender, and LGBTQIA injustice. Under his leadership, the center successfully challenged NYPD's stop and frisk policy and profiling of Muslims, ended long-term solitary confinement in California's Pelican Bay prison, and established persecution of LGBTQIA people as a crime against humanity. Previously, Vince monitored South Africa's historic Truth and Reconciliation Commission hearings and was a senior staff attorney at the ACLU and a criminal defense attorney for the Legal Aid Society in Brooklyn. He's a frequent guest on MSNBC and Democracy Now! And has appeared on Moyers and Company with Bill Moyers, CNN, and Fox News. His writing has been featured in the New York Times, The Guardian, and on Huffington Post, as well as CNN.com, among others. And last but not least, Ilann Maazel. Ilann is a named partner at Emery, Celli, Brinckerhoff, Abady, Ward, and Maazel, also known as Emery Celli for short, nationally recognized litigation boutique that focuses on civil rights, commercial, criminal, and ethics matters. Ilann is well known for his work advocating for the most vulnerable, including survivors of sexual abuse, disability abuse, bullying, police abuse, prison abuse, wrongful convictions, and all forms of discrimination. He also helped save the High Line in New York City. So if you had time this weekend to enjoy the nice weather and you were there, you can thank him for that. He led the 2016 presidential recount effort in Pennsylvania. He has brought class actions to end the tampon tax and delays in Bronx criminal court, provide services to disabled preschool children, reduce violence in New York City prisons, and defend millions of Americans surveilled by the NSA, in addition to numerous successes as a commercial litigator. Mr. Maazel has been published in several national newspapers. He blogs for law.com, writes for the Civil Rights Litigation column for the New York Law Journal, including last month's column, Rule of Law, Not Rule of Trump, and is a frequent commentator on civil rights issues in the national media. So I'm going to ask a few questions, and hopefully we have some time for a few questions from the audience, but I think we can jump right in. So for everyone on the panel, I'm interested to hear your thoughts on recent executive orders from the president. We've all heard about executive orders targeting law firms, educational institutions, and other organizations, and they raise concerns about the executive branch's overreach. How do these actions fit into a larger playbook or effort to undermine the rule of law? And what safeguards exist to protect the rule of law? And we'll start with Ben and then work our way back.
Hi, very happy to be here. Thanks for inviting me. So yeah, I mean, I think it's important to put the attacks on law firms, particularly the executive orders, and also sort of the legal community more broadly in context. So this is right out of the authoritarian playbook, right? This is what autocrats do. They come into power and they try to co-opt or eliminate the centers of opposition and potential checks on their power. So it's really important to see and understand the attacks on the legal profession in that context. It's really the same thing as the attacks on the courts, attacks on universities, attacks on the civil service and the Department of Justice in particular, attacks on the media and science and health, on independent agencies like the FTC and the Fed, the rumored forthcoming attacks on NGOs or nonprofits. They're really all the same thing. They're an attempt to undermine and take off the field other independent entities and bodies capable, that are sources of authority, capable of checking the president and the administration. And I want to echo something that I think the last panel covered really well. Law firms in particular play an absolutely critical role in our system of checks and balances, in the opposition of any functioning opposition in Congress. An independent judiciary is perhaps the single most important check that we have right now on the administration's attempts to consolidate power. And that independent judiciary does not work without lawyers willing to come into court and represent clients who are challenging the abuses of the executive or overreach. Again, the judiciary just cannot function without these legal advocates. And that's why this administration is so intent on removing the legal community and law firms in particular from the field. I will say, as someone who works at a nonprofit, Protect Democracy, we can play some of this role, and other nonprofits, big community of legal nonprofits. I think we do really good and excellent work, but we absolutely cannot do it without support from law firms. In 2023, large law firms provided something like 5 million hours, or maybe the equivalent of about $5 billion of pro bono legal services. And we simply cannot do our work on anything like the scale that's necessary without support from the private bar. It's no coincidence that the executive orders that we've seen so far, among them have targeted the 3 biggest law firm pro bono service providers. That's Jenner, Covington, and Wilmer. So again, it's really important to understand the attack on these firms, and and also I would say the ongoing flirtation with disregarding court orders as 2 sides of the same coin. They're fundamentally an attack on the rule of law and on democracy.
Thank you. Hello, everyone. It's wonderful to be with you as the not quite yet soon to be retired person in the room. And thank you, Chris, for the for the wonderful introduction. Out of all of that, the only thing that you have to remember is that I started off at legal aid. If you cut me, I bleed public defender. And that actually, I think, fuels the way that I move, excuse me, the way that I move through this moment. Ben, I totally agree that this is right out of the authoritarian playbook. And I think one of the challenges for our profession is to actually think more politically and less transactionally. Part of the challenge that we have is that when big things like this happen, when there is an executive overreach, similar to what happened post 9/11, the courts are the only non-sort of self-executing branch of government that we have. The administration can issue executive orders, Congress can hold hearing committees, and Article 3 judges need cases and controversies. In order to get cases and controversies, it cannot happen without the legal profession, without us. And very often, what we're seeing in these moments is the rest of the world is waiting to find out if the rule of law will actually hold. So this moment, there are a lot of moments that are not about us, but this moment actually is very much about us. And the good news is that there are so many nonprofits, Protect Democracy, CCR, where I come from, law firms like Ilann's law firm that are lining up and that are taking on clients and taking on issues to be able to push back. Because clearly what's happening with these executive orders is not lawful. There's no scenario in which they are lawful. We all know that, and that's part of the reason why there are 10,000 people here, because we're like, what the heck are we going to do about it? But what I mean about the political framing is this. When we think about the law as, gosh, wouldn't it just be great if we could just get back to the status quo of, what was it, 3.5 months ago? That would be terrific. And I think in most administrative swings, that might be enough. But in this one, I'm not sure that it is. It's more important, I think, for us to think about what kind of moves that need to be made under authoritarian pushes, rather than what moves should be made by administrations that just have a different view than we do. And that's why, getting to the executive order question, Chris, that the executive orders targeting law firms and targeting universities, there's been some very disappointing responses to that. And one of the things that we know historically, and that I hear this from human rights lawyers from around the globe in authoritarian regimes, that they say that when the center capitulates, it actually strengthens the authoritarianism. And that's the moment that we're in right now. Our center is flirting with, is thinking about, is weighing the risks of capitulation versus the risk of fighting. And I totally understand what that calculation looks like, but I would really urge all of us in this room to think about the risks slightly differently. If no law firm was involved in any litigation, if the private bar was not involved in any litigation, we would lose. And we can't allow, we have to give the judiciary more to work with than just under-resourced, scrappy organizations like ours. And we are fantastic, but we need to give more to the judiciary than that. And that's really where you all very much come in. Last thing I would just say is we are in a different moment than we were 20 some odd years ago during the post 9/11 period. You will remember George Bush expanded power extraordinarily. A number of us were sounding the alarm, fighting back, and that sort of thing. Unfortunately, a lot of the deference that the courts gave to the administration, particularly when the administration evokes national security, is a point that I think is making at least me a little wobbly right now. What do I know and what I don't know? I don't know whether the courts will give deference to the Trump administration. I do know that the Trump administration is unshameable and that they will continue to push for whatever they want, regardless, in some context, of what the courts say. So we're in a tremendous moment, and I think that those executive orders, I think, really tee up a larger conversation about what it looks like for the law over the next probably 18 months or so.
Good afternoon. Thank you so much for having me. And I want to start by saying that my firm, Emery Celli, will never capitulate, cave to, collaborate with, appease, or make a deal with the Trump administration. That will never happen. And there are many, many firms and many, many lawyers who feel exactly the same way. And so there are firms out there that have fought this administration, and they are winning. And every firm that fights will win. So we need to fight, and then we need to win. And my first message to the law firms that did capitulate is, it's not too late to change your mind. Not too late. So there's this great Above the Law blog. I don't know if you saw it, but we are entering the Lando Calrissian Vader portion of the executive order. Trump is going to alter the deal. He's already trying to alter the deal, and I think all these firms will regret the day that they tried to make a deal with a man like this. You cannot make a deal with a man like this. They shouldn't have done it, but it's not too late to turn back. So that's my first thought for the legal profession. But I agree exactly with what Ben and Vince said. I think our first job is to recognize the threat that we're facing. So the greatest threat to the rule of law and to democracy and to freedom in the United States of America is, without question, the President of the United States. This has never happened before, as far as I can tell, as far as from my study of history, but we are in that moment. And I think we all need to be clear-eyed about that threat. We need to understand it. We need to share our views on that with others, with our friends, with our colleagues. Because I think it's so easy to look the other way or say, maybe it's not so bad, or maybe we're not in this moment. We are. And the sooner we recognize the threat, the sooner we can fight the threat. And that fight can take many, many forms. As lawyers, we're good at filing lawsuits, whether pro bono or otherwise. We should bring as many lawsuits as we possibly can to stop the administration from violating the rule of law. And there is an inexhaustible need for lawyers right now. Inexhaustible. Our phones are ringing off the hook. We can't do every single case. Others are doing wonderful cases. Every single lawyer in this room can take on a pro bono case or a non-pro bono case, whether it's representing some of these students who are being disappeared because they wrote an essay in a school newspaper, or whether it's all of these agencies that are being defunded by the Trump administration when they were funded by Congress. There's such a great need out there for lawyers. And so I would encourage everyone in this room to fulfill that need, to fill that need, and fight the good fight. And not just fight the good fight, but win it. And that's my opening remark for the session.
All right. Vince, I think you mentioned that we may have to look past the status quo when thinking about the next move and how do we get past what we're dealing with currently. What lessons, if any, do you and Ben, also want to hear from you? What lessons do you borrow from lawyers from other regimes that have experienced sort of similar shifts towards authoritarianism?
So, thank you for the question. One of the sort of defining features of talking with lawyers that have worked in Hungary or have been kicked out of Hungary, that have been kicked out of Russia, that worked in Brazil, that work in India, has been that the separation between the lawyer and the client is largely a U.S. Western concept. We're the lawyers, they're the clients, we're advocating on their behalves. What happens in authoritarian regimes is that lawyers and clients are in the same boat. Lawyers are dangerous because they represent the clients are dangerous because of the positions that they take, and both of those entities essentially get captured and disappeared by authoritarian regimes. So what folks have been telling me to tell you all, or to tell my lawyer colleagues, is that the days of arm's length transactions with people that are under threat are over. That we have to envision ourselves as fighting for our own lives, and not just our own professions, but our own lives, as well as fighting for the lives and well-being of our clients, as well as understanding that the rule of law can only be vindicated through our action and our bravery. And I'm reminded of one of my mentors that there was some crazy situation I was facing, and I was very nervous about it. And the lawyer, my mentor, reminded me. Actually, it was Harry Belafonte, who was my mentor. I was very lucky to have met him, and he said that that bravery is not the absence of fear. Bravery is acting because you're afraid. And that's really stuck with me, and I think it's a good moment, a good thing for us to reflect on right now in this particular time, because there's risks to all of us. There's more risk to the students and the folks that are under attack, the millions of immigrants and migrants. Our client, Mahmoud Khalil, who was, as many people know, was abducted and now is in immigration detention, and we've filed habeas corpus challenges. We've filed litigation under the All Writs Act to get him from Louisiana back to New York. And similar to what's been happening in the Garcia case in El Salvador, the government is just moving around, and they have no intention of, I think, they seem to have no intention of complying with lawful judicial orders. And that, I think, that specter of we've done our best, we made the best argument, we actually won in court, is likely not going to be enough, I'm afraid. I think that there are two outcomes with respect to our endeavors with the judiciary. I think one is that the judiciary stands up for the rule of law. They're very clear about where the lines are drawn, and they articulate them very clearly, and they make demands of the government to do the right thing. The other is that they don't do that. I think that they will do that. I think the courts will do that. The challenge is that when they do that, what do we do when the administration says, yeah, no? And I don't think there's a person in this room who, maybe 10 years ago, we would have a debate about whether that's possible. I don't know if there's a person in this room that thinks that it is impossible for that to happen now. And I think even that specter should call us to engage and embroil ourselves and to do our best efforts, even at risks to not take on risks that are outrageous, but take on some of the risks that our clients have taken on by speaking out, particularly those of them that have done nothing more than articulate a position. That's really what we're being called to do, and that's what I'm hearing from human rights folks from around the world. That is the shift that lawyers need to make in this country.
Yeah, I love everything Vince just said. I'll just add, well, actually, I hate everything Vince just said, but I agree with it. I will just add 2 points. One is, as I said before, none of this is new. Trump is following a playbook that we have seen in other countries that have gone down the path of autocracy or authoritarianism. One of the first things autocrats do when they get into power is go after the independent bar, again, because the independent bar is one of the most powerful checks on the consolidation of power by an authoritarian executive. So you can look. We just submitted an amicus brief in several of the current EO cases on behalf of the New York City Bar and other bar associations that details some of the history from 1930s Germany, from Soviet Russia, from post-Soviet Putin Russia, from Hungary, from Turkey. We see this over and over and over again. The executive essentially attacks, delicenses attorneys who don't adhere to the party doctrine or party ideology. The second point I will make is that so when we first founded Protect Democracy back in early 2017, we hosted a gathering that included pro-democracy advocates from other countries that were further along towards sort of the slide into authoritarianism, at that time much further along, not so much anymore. One thing that sticks with me from that gathering, like 8 years ago now, was a woman from Hungary who was, very bravely a member of the pro-democracy movement there. And someone asked her, if you could go back to the beginning of the slide into authoritarianism under Orban, what is the one thing that you wish had happened differently? And she did not miss a beat. She said, the fracturing of the pro-democracy coalition. So one reason that these executive orders are so effective, not to mention the attacks on universities and in other sectors, is Trump's, or probably someone around Trump, has studied what, the examples from abroad. And the idea of sort of going after firms one by one, not a broad-scale attack on the whole legal profession, but just picking off firms one by one. That is a classic divide and conquer strategy, and it makes other firms extremely reluctant to stick their heads up. They believe, erroneously I think, that if they just keep their heads down, they will be fine. Again, I think that's wrong, and we can talk more about that. But it allows Trump to just to achieve his goal of silencing essentially the entire legal profession by just making an example of a few law firms. And we will see this playbook repeated again and again and again against universities. I guarantee you it will happen against NGOs. And the way to fight back against that is to stand together. This is a massive collective action problem, and you can defeat it by having each other's backs, by all firms standing together, by firms standing with universities and NGOs and the media and other parts of civil society that are going to be targeted by this administration.
Thanks. So this panel is aimed at discussing what can lawyers do to stand up against the recent attacks. And I had a conversation with an associate who resigned from their firm in light of an agreement with the Trump administration. And I was shocked that the associate said that they were hopeful, right? They were hopeful that attorneys and folks in the legal profession would step up. So what would you say young lawyers, including law students, law firm associates, junior lawyers in government and public interest, what can they do to uphold the rule of law, even if their employer or their law school hasn't taken any action or has been silent in the face of recent attacks? And Ilann, let's start with you.
Well, let's just start with law students know which firms are doing what. There are lists out there which are quite interesting. Capitulation, hasn't spoken out, fighting. And so students can align their values with the place they go to work. There are students who've had offers from certain firms that have decided not to work there. They want to work somewhere else. We can always vote with our feet. If you're at an institution that where you don't believe they've acted correctly, you can always leave. Of course, that has consequences, but sometimes we have to take difficult decisions. And so, the other thing I would mention is that this is anecdotal, but I hear this from people who are working in law schools, say that there's a huge groundswell now among law students to work in mission-oriented firms or nonprofits. They want to save the world. They want to save our country. They want to save our planet. And I think that's a wonderful thing. If one good thing comes out of this, and that is that we have a generation of young lawyers and young people who want to take a stand and take action and succeed where others have failed, I think that would be a wonderful thing. And so people maybe are galvanized. Can I just note three hopeful things that happened in the last week?
Absolutely.
Okay.
Of course, please do.
I think there is room for hope because we keep hearing about setbacks. We have Harvard University, which stood up, which I think was very important. We have the Supreme Court this weekend, in my view, woke up. I think what they did was remarkable. 7 justices did not wait for the Department of Justice to file a brief, did not wait for their dissenting colleagues, did not trust the government when they said they weren't going to fly people to El Salvador. They just acted. And that tells me that this court has lost patience with and trust in the executive branch. And it's about time, but I think they did the right thing. And we were talking about the Trump administration rushing to the Supreme Court to get a stay. Well, the ACLU played that game last weekend, and it paid off, and good for them. So that's the second thing. And the third thing, which in some ways to me is the most hopeful, is did you see that video of Senator Grassley's town hall? Did anyone see that? Okay. So all these folks in Iowa, these are not, Manhattan liberals. They were very upset, not with tariffs, not with inflation, not with the price of eggs, but with a man who was sent to El Salvador without any kind of due process. And that really upset a lot of people. And that told me that there is a feeling and a tradition and a culture in this country that we actually do care about civil rights, and we do care about our Constitution, and we do care about our freedoms. And one day it'll be that fellow who's sent to El Salvador, and the next day it might be my neighbor, and the next day it might be me. So I think people are waking up to that reality, and that just gave me enormous hope. So, hope.
So, lawyers' first instinct is sometimes to address these attacks on the rule of law in the courtroom, to file a lawsuit. But are there other arenas, for example, social media, cable news, print media, it still exists, where lawyers need to put up a fight in support of the rule of law? And what does that fight look like? Vince, we can start with you, and then we'll go around.
Okay. Yeah, how many people are on TikTok? No, I'm kidding. How many people's kids and grandkids are on TikTok? Yeah. After I believe it was Modi came into power in India, there was a move to remove judges from the Supreme Court. And there was a massive lawyer demonstration that happened in India. They actually did solidarity actions around the country that happened in New York as well. And I remember thinking at the time, my goodness, what would it take to get a whole bunch of lawyers out on in a demonstration? And it does take something like that. But the point is that it was so dire that the lawyers actually stood up. And this is part of what I was talking about when I was thinking about how we should think politically about it. And I don't mean in the Democratic versus the Republican context. You can believe what you believe, you can vote for who you want to vote for, but we know when the rule of law is under attack. And so I would invite the lawyers in the room and the law students to sort of shed whatever political orientation that they have in terms of bicameral politics, and to think more about what's our role at the in terms of the demonstrating the rule of law. So that would be outstanding. I heard that there's a May 1st demonstration. I think people should definitely go to that. And I also think that there might be conspicuous statements made by groups of lawyers, including this Bar Association, which I know has done tremendous work around this, but to not let our associations do the work for us, that we need to be standing up as individual lawyers. Number two, I guess this is hopeful news. When we were doing, the Center for Constitutional Rights was doing the Guantanamo litigation, which we started in 2002, and in 2004, we had a case before the Supreme Court, Rasul versus Bush, that recognized that habeas corpus applied to the men in Guantanamo, and then because of that, actualized lawyers being able to go down to Guantanamo and represent the men. And my tiny little organization helped recruit roughly 600 lawyers to represent the 779 men, which we think of as CCR as one of the largest sort of mass mobilizations of lawyers in the United States, at least in recent memory. And that was a lot of work, but when we look back on that moment, they call themselves the Guantanamo Bar Association to this day, that having a number of lawyers to be able to sort of stand up for the rule of law, particularly representing people who at the time were considered the worst of the worst, Apparently now there are new people that are considered the worst of the worst. But having that conspicuous lawyering happening was incredible. And in 2007, some of you will remember this, I believe it was a Defense Department employee named Cully Stimson, issued a public statement that was aimed at the clients of big law firms and said, do you know, clients, that your law firms are representing these Guantanamo detainees and you should fire your law firms? And almost instantaneously, all of the law firms and the bar rose up and pushed back on that immediately. It caused him to issue an apology. It also cost him his job, because the idea that lawyers could be attacked for defending the rule of law back in 2007 was anathema. It's still, of course, anathema now, but and I'll give us all a breather because it has only been 4 months, and Congress hasn't even gotten started yet, folks. So we are in this stage of shock, but I think now actually organizing the lawyers around conspicuous statements and stands around the rule of law is absolutely important. Lastly, with the law students, I think it's fantastic that the law students have a list of undesirable law firms, because it wasn't that long ago when a couple of years ago, the law firms had the list of undesirable students, if you remember that. So don't sleep on Gen Z, because they will be coming for you. So I'll leave it there.
Yeah, I mean, I totally agree that I think it is really important for lawyers to continue to go into court and litigate, but that is not alone going to win this fight by any means. So, I would say if and when, and I think it's really when, not if, the administration sort of outright defies a court order, it's going to be really important to have sort of mass mobilization. I mean, I know, there are plans already in the works to do that, but that's ultimately the thing that I think is going to make a real difference, is getting hundreds of thousands or millions of people into the streets when that happens. More generally, I would say autocrats thrive on complacency. So do whatever it is you can, no matter how small it seems. Speaking up, writing letters to the editor, calling members of Congress, attending protests, anything you can do to use your voice to break through the collective action problem. Because I think even those small, what seem like very small things, create a sense of community and solidarity and unity in the face of what is otherwise a very frightening autocratic threat. It breaks through the instinct for everyone to kind of put their heads down and try to go unnoticed and try to escape whatever sort of punishment or retaliation from the government that might come if you do speak out. So again, I think just like doing those things to give everyone else a permission structure to also push back.
There are also some lovely states we can move to: Wisconsin, Michigan, and Pennsylvania, just for example.
Sort of a follow-up to that is, how can legal professionals effectively communicate the importance of the rule of law to the broader public and counter misinformation or narratives that undermine it? And I'm thinking about when you're in your barbershop and you hear someone say something like, "Oh, that Trump, he's something else. This sure, he's sure doing his thing," and you got to jump in and say, "Well, actually, here's the impact of what he's doing and how it impacts everyone." How can lawyers take their training and turn it into advocacy outside of the courtroom? So it could be social media, it could be in person when you're with colleagues or family or friends. And is that something that I guess all of us should be doing on a daily basis at this point?
Well, Vince, you were on Fox News, so I give you props for that. Tell us about that.
So we're talking about messaging and what can we say. So I will say that the challenge that we have, I was that when I would go on Fox News or conservative stations, particularly talking about Guantanamo, and I would be wiping the floor with the host. They didn't know anything that was going on, and everything was flowing. And I felt really good after the program. And I asked my friend, how did I do? And I said, well, I heard your voice, but every time that you talked, they just superimposed the Al-Qaeda guys on the monkey bars. So I'm not really sure how you did. I mean, my point in telling that story is, the other thing that happens, by the way, on the Megyn Kelly show, I was there talking about stop and frisk, and what they also did was they turned down the earpiece in my ear when I was talking, and so then I would stop, and then when I was making a good point, then they would just change the subject. But anyway, so what does that have to do with you all? It's that it is very, very hard to message what we think of as simple foundational things like due process to other people, because it's been so ingrained in folks that due process is the thing that the criminals get to have loopholes so that they don't get punished. And I will confess that I haven't been super successful in doing it in an inviting kind of way, but I've been a little bit more successful in doing the opposite of what Ilann does, which was to sort of instill people with fear about what happens if we don't have it, rather than the joy of the Constitution. So one of the things that I sort of point out, and I'll point it out to you, is that there is a reason why due process and the First Amendment are under attack with this administration. And the due process piece is largely because due process is the thing that keeps this administration from doing mass deportations. It's pretty much it. And what I fear is actually happening, where I think this is going, we've got our eye on the Insurrection Act, because as a practical matter, one is not able to deport millions of people simultaneously in real time without the aid of the military. And so when this administration talks about national security, which then they use national security for everything, it does give some courts pause to sort of say maybe we should give some deference to the political branches because they have all the information that we don't. And what we have here, unlike the Bush administration, is that it is patently false and obvious. There's no secret information. There's no military intelligence. They just want to get rid of immigrants because it's politically a winner for them. And so what I say to folks is that the due process is the thing that keeps the military from being on our streets, not only deporting people, but arresting protesters or backing up the police when they're, rampaging in black communities, or backing up local right-wing politicos that want to demonize LGBTQ. And it seems so strange and far-fetched, but that's, I think, that very important fundamental due process piece really is the thing that not just slows things down, but it actually shows how impossible it is to round people up and disappear them the way that this administration has started to do.
So we have a few minutes. I want to open the floor to questions if anyone in the audience has some. I'll say, okay. This is the young audience has questions for us. We'll start here and we'll go around.
That's a great question. I'm not clear about how that's happening now, but I can talk about a little bit how that happened under the Trump administration and somewhat the first Trump administration and the Bush administration. Particularly, there are veterans organizations, people that have served in the military, people that have been in active duty, that found themselves on the wrong end of human rights violations because they were ordered to do it. And so there is a network of of folks that have that discussion with people that are currently serving about where that line is drawn, being clear on what they can do to say no, how that gets moved up the chain of command, and I think most importantly, what that's going to mean for your career. I think the situation has been that where under previous administrations where people have spoken up, they've essentially ended their careers were ended because they were speaking up. But that also still encouraged other people to do that. So that those conversations are happening. I'm not privy to them.
I think a hand in the back.
I'll just say, as a lawyer who's still paying off student loans and who works for democracy and rule of law, I like that idea a lot.
We'll talk with Brett about the budget if we can afford to do that, but I don't know. Question.
I've been a member of this association for 56 years, and every time I'm in this room, I read the words carved into the dais. The bar, if it is to continue, must be bold in defense, and if need be, bold in aggression. These are desperate times. This is the time for aggression. So what can this bar association do? New York City is the place where most of the firms who caved to Trump are located. I think there should be a vote of the membership with ample opportunity for affected parties to be heard, of course. There should be a vote to expel from this membership all the partners of Paul Weiss and their ilk in all the other firms that caved. I think the vote would be overwhelming in favor of expulsion.
I very much appreciate how you folded due process into that. So, and also, and I think that the words are very, very clear and important. Let me suggest a different way. One of the things that we're facing now is, Ben started out talking about how the dividing folks is the way for them to win. So there's another opportunity. Ilann pointed out that there are now opportunities for some of these firms to rethink things. And my personal view, in terms of having a fully fledged supportive bar in New York, is I would much rather not having people voting to expel folks from associations, but I would much rather have people that have distanced themselves from the words here, rethink that and come to this association and say, you know what? We were wrong. And not only are we back, we're going to help take the lead on this. And I feel like that's what we actually need at this particular time.
My issue is that lawyers who think false law, not such a bad situation. Relax. You go through these administrations. I don't know how you light the fire. Aren't here, and maybe you should be. Guys, persuade them that, well, this is not Republican or Democrat. Lawyers don't see it that way. Those people will not be there on May 1st. They think we're just alarmists. The question is, what can we do to get the message out so that people understand this is really an issue?
I don't know that I have a direct answer to that question. I will say one thing, and I'm curious if others have a better answer than I do. When I started working in this space in 2017, so what does Protect Democracy do? Our mission is to prevent American democracy from sliding towards a more authoritarian form of government. And people would be like, wow, that is paranoid, or, you know, you get a lot of eye rolls to that, the description of the mission statement. I never get that reaction anymore, right? I travel in certain circles. I'm not talking to a lot of Trump supporters, but I do think there is a pretty broad understanding in this country now that we are off the rails, that we are heading down a pretty dangerous path. So I don't, you know, for the lawyers who are paying attention and don't see that now, candidly, I'm not sure what the message would be at this point to convince them. I mean, maybe when you know, the administration openly defies a court order, that will change some minds. But you know, at this point, candidly, I'm not sure what more you need to see to understand that we're in some trouble. I don't know. Do either of you have other thoughts?
Well, in the old days, when people said, "What do I do for a living?" and I said, "I'm a civil rights lawyer," they'd say, "Oh, that's nice." And when Donald Trump was elected the first time, then people would say, "Well, thank you for being a civil rights lawyer." And now they say, "Please do something." And so I think there is an urgency out there, and it's slowly but surely it's hitting more and more people, including those folks in Iowa. And maybe there'll be some who just never see it until it's way too late, but I think most people are starting to get it.
I mean, I love that the Big Ten did that. I think it is exactly the right way to respond, and I think it gives. I am encouraged with, you know, as Ilann mentioned, with Harvard standing up and other universities now seeming to be more going on offense or banding together. I think you will see that in other sectors that the administration attacks. I've never worked at a law firm a day in my life. That's not true. I was a summer associate at Paul Weiss, actually. But other than that, I've never worked at a law firm.
So was I.
I've never worked at a law firm a day in my life, and I'm not going to pretend to fully understand what motivates law firms. I'm with Ilann. I don't understand how a sophisticated lawyer at a law firm could decide it's a good idea to cut a deal with a man who's never stood by a deal in his entire life, and I think I agree they're already coming to regret it. Candidly, like, I defer to those in law firms who understand the sort of internal workings of firms better, how you convince firms to join together and take some collective action. I assume that clients sort of insisting on it is one potential path. I don't know if that's realistic at all. I will just say that one thing that we heard sort of right after these EOs started to be issued is a lot of people at firms told us not only were they not banding together, but some firms were poaching the clients of the firms who have been targeted by EOs. I find that appalling. Like, that should be, I understand sort of some of the motivation, you know, that law firms are not motivated by altruism. They're there to make money, but like, that should just be off the table. It should be, no right-thinking person should think that is acceptable under these circumstances.
Well, what if the New York City Bar Association drafted a pledge that all the large law firms could sign saying, we will not poach clients from other firms attacked by this administration.
Yeah.
How about that?
I think the question was, or the question was, what do the panelists think of the possibility that the Perkins lawsuit is successful in terms of striking down the deal, and then the other firms would sort of see that as a sign that their own deals were null and void. Is that a more likely scenario than sort of on their own, the law firms deciding they're going to go back on the agreements that they've reached?
Well, Paul Weiss entered into that agreement after Perkins Coie had already got a TRO. So, you know, every firm that has fought the administration has won. Every single one. Sussman Godfrey won, Wilmer Hale won. I mean, these are all TROs, and the cases remain to be finished, but I think that will be the way that the cases end. So it may take more than just other firms winning for some of these firms to change their mind.
Actually, I think we're about time to move to the next segment of the program. So I wanted to let the audience know that following this panel, we have breakout rooms for different workshops. So in this room is going to be the law firm breakout room, the private firm breakout room. So if you're interested in sticking around and having discussions about what firms can do, what people within firms and people who are interacting with firms can do to stand up to the rule of law, you can stay in this room. If you're interested in the government nonprofit breakout room, you'll be heading to the CLE classroom. And if you're interested in the law school, law student breakout room, that's going to be in the Tweed room, which I believe is just across the hall in the reception room to the right. But there are folks outside who will be able to guide you to the various rooms. But I wanted to take a moment to thank the panelists for their brilliant comments. I want to thank you all for coming out and also contributing very thoughtful questions. And I want to thank the City Bar for having this program because it is important and it is timely, and we need to do even more, right? So thank you for coming out.
Hey, Brad. Nice to see you. Oh, no, it's a pleasure.